Okay, good evening, everyone on Facebook Live. Tonight we are going to be talking with Ben Wagner of Troutman Pepper. This is one of those interviews that I've been waiting for quite a while. He's involved with some pretty high-profile cases right now. A couple of them that we have highlighted before this broadcast are the Capture 11 and Auto Products, the Manico Group versus Hollis Company, and Lontex versus Nike. Quite a bit going on in the trademark world, trademarks and copyright world. And I wanted to get him on here because it's something that a lot of people deal with in their business. And I've had questions about it. I've had people asking me to give them referrals. Um, people to do their trademark and their copyright, and why is it important, and then how do you protect yourself. So we're going to talk to Ben tonight about all of those things and some of the cases that he's worked on. And rather than me go through all of the highlights of Ben's resume, I'm going to have him come on and introduce himself. Right now, actually, he is standing by. There we go. I see you.
Okay.
Awesome.
Great. Good to be here. Hello, Kaylin. Glad we got through those technical issues.
Yes, great. We can hear you loud and clear, and this is so good. So, Ben, I would love for you to just introduce yourself, talk about the kind of legal matters that you deal with on a regular basis, and what you do, and what your background is, if you don't mind.
Absolutely. So I've been with big firms for about 15 years, since 2005, working about half. It started out half commercial litigation, half intellectual property, and it's just it grew into mostly intellectual property. And what intellectual property is trademarks, which you might think of as brands like Coca-Cola, copyrights, which would be images or movies or really anything creative. Creative expression, a book, literally software code could be a copyrighted work. And then there's patents, which are essentially monopolies on creative, on useful inventions that folks come up with. So those are the types of cases that I've really poured myself into. And I joined Troutman Sanders, which is now Troutman Pepper, back in 2019, over from Mintz Levin, and have been growing the practice over here to really focus on a lot of soft IP, but we've just filed some big patent cases as well that we're excited about. So that's a little bit about me. I generally stay on both plaintiffs and defendants side. Right now I have about $460 million worth of claims that I'm on plaintiff's side for, between the various matters that I'm representing. So it changes in every given year, and the team that I have changes in any given year. It's so fun. I got folks from all across the country. We have 20 offices, and I get to work with probably 5 or 6 offices at any given time.
That's fun. Yeah, you can. And when you talk about what you do, you're so passionate about it. And it's important. And sometimes people think, going through all the trouble of getting a trademark as a smaller business, then I've got to defend the trademark, or I have to use it, or those kind of things. Before we dive into some of the cases, can you talk a little bit about why it's important for a small business to get their intellectual property protected?
Absolutely. I will tell you that it's staggering. The majority of, so let's just fast forward to when these small companies become big companies. Some of the biggest companies, like the Fortune 100 companies, the majority of their assets are intellectual property. So a lot of it is patent rights that they hold. Folks like Qualcomm, Apple, Google are always fighting billion-dollar cases over patents. But to put it bluntly, if you're not protected, people can and will just take it, whether or not you as a small business think that's fair or it's right. It is something that they can and will do. I have a client who literally has been told, despite having a patent, but what are you going to told by the big boys, but what are you going to do about it? We're going to come out with our own competing technologies. Yeah, but we get the patent on it. You can't use our patent. They said that's just what we're going to do. So absolutely, having the IP protected will give you the most rights, and having it protected early will give you the strongest rights, especially when it comes to copyrights and trademarks. It's much better to have a federal registration than to just float by and deal with the problem if it arises.
So if a larger company tries to take on, to try to use your intellectual property, but you did protect it. It is, you can fight that, and it's
Absolutely. Let me give you an example. There's a
okay.
fossil. There's a lawsuit that came out of the 11th Circuit, fossil versus it's Romag versus fossil, and it went up to the Supreme Court, and it was ruled on back in, I think it was April, and I actually did a number of even presentations, articles on it. You can see it on my bio. It was a big case. The Supreme Court, and it was a trademark case, and literally the jury found that of all of the use that Fossil made of this trademark, that of all the money that it made off of it, only 1% was attributable to the value of the plaintiff's trademark, because the plaintiff's trademark was just so small and so not, let's just say the jury didn't think it was very meaningful in the process. But because the jury wanted to make sure that Fossil learned its lesson, and that that it wasn't careless again in the future, the jury thought that all 100% of the profits for the infringement should be awarded to Romag, the smaller company. So that gives you an idea. I mean, when you play with the big boys, even if you're a small company, if you have a federally registered trademark or a copyright or a patent, you can be looking at those types of recoveries potentially. So it makes the world a little bit more fair, and it certainly can work out good for you if it turns out that the person that squashes you and tries to take your brand turns out to be a big company.
That's good to know. I think some people feel defeated, or they think that, they're only small, so what's the point of it? So that's really good to know, actually, for a lot of people out there that are starting up.
And what I will say, Kaylin, is I think that folks are really pinching pennies when they do stuff.
Oh no, we lost Ben again. Darn it. Not sure what happened there. We will get through this entire interview because there's so many cool things I want to ask him about that we haven't even touched on yet. But as you can see, he's a wealth of information already. And thank you for ignoring the fly. Oh, he's coming back. All right. Okay.
I'm back. I'm back.
Yep.
So what I was just saying was, look, there's a very pinching pennies sort of mentality for younger companies, and we totally get that. We have incubators, like SDSU has a nonprofit group that I forget what the name of it is called, but I've gone there and volunteered and helped answer people's trademark questions. But let's just put it this way: you can't afford not to protect your intellectual property, because it is the thing that separates you a lot of times from the commonplace. And as good as you think your idea is, someone with more money and more resources and more reach can quickly copy you if it turns out to be a winner.
Well, let's talk about some of the examples of that we had highlighted, that we were thinking about touching on. The Otter company, that we talked about that, that's currently going on, that you're working on now. What are you able to tell us about that particular case?
So that lawsuit was filed back in August, and it is a lawsuit against Otter Products, who you may know as OtterBox, who also owns LifeProof. So what happened was, my client, Justin LaRue, who it's the owner of the copyrights is now Capture 11, was a photographer for LifeProof, came in as independent contractor, did some really amazing work. I mean, you think about when you look at LifeProof on the internet and you look at their advertising campaigns, the look and feel of LifeProof, and the reason it blew up into an international brand was a lot to do with the amazing photography that captured a look and feel of the extreme or outdoor life that, whether or not you're sitting in a library or you're out on the slopes, you relate to that and you want to be a part of that. So you're willing to pay for a premium product that brings you that. So they had said, hey, we don't need any more photographic services from you. We don't need your photography anymore. And that lasted for about a month. And then they brought him back to do some shoot-by-shoots. The problem was they only paid him enough to get rights to, at most, use it for a particular product they were shooting. So, okay. So they didn't have any contract to buy broader rights. They said we'd come back to you if we need to. They never came back to him. And the problem was then they blasted his pictures on cases, on social media, on advertisements that went way beyond trade show booths, that went way beyond the limited case or the product that they were shooting for. And then ultimately, when he found out about that, he brought that to their attention. It was very reasonable, but you know, it turns out they just didn't want to reach a resolution, so we had to bring a claim to protect his rights. And so now we're at a lawsuit in Colorado. And look, it's $1 billion a year sales company is what its public documents disclose. And I think we've done the calculations. It could be as much as $125 million worth of product was pushed with the benefit of Justin LaRue's photos. So that's the type of thing where, you know, it's so important to get the rights, to make sure that you have documentation that accurately expresses who gets what, and then to make sure you're doing business with the kind of people you can trust all the way. They're not going to come on your back and do something you were expecting.
Right. And I think that's a huge thing, especially as you're growing in your business. If you're going to use anything, because what people don't understand about creative work is somebody's concept in their mind of how they shoot it, the lighting they use to shoot it. There's a lot of decisions that are made, right, in those creative decisions and how they're going to market and advertise. And so that's essentially what's protected, right, is their way that they're using the material. So anyone can shoot a product, but there's other things that go into it.
It's actually the photograph. So if you would look at, for example, the nude case that Life Proof sold, it would have pictures that Justin LaRue had taken and put it on the package itself. So to try to get someone to pick it up off the shelf, it's got this person doing something amazing or something that really connects with the audience to make them want to pick it up off the shelf instead of picking up those other products. So it's actually the picture itself that is protected. So, and what I will tell everyone, just simple advice, it doesn't matter if it's email, it doesn't matter if it's a contract, put something in writing and put a signature block on it. This doesn't put backslash and your name to memorialize what it is, because you will be amazed at how kooky some of the copyright rules are. And there are some types of copyrights that you can have as a work for hire, for example, but there are some that even if you don't have a document, it's not a work for hire. So make sure you have a document that says who owns what, and if there's any restrictions on it, that says the restrictions. It's just so much easier than coming back after the fact when folks aren't getting along.
Yeah, absolutely. Okay, the next case that we were going to talk about involves the Hollis company, and that is a copyright case. So how is that? That one's a little bit different.
That's absolutely, it's very different, and you'll notice all of these lawsuits are very different, and the folks that they speak to in the audience is very different. So, for example, you're thinking of a trademark case. It's Manico. It's the Manico versus Hollis company. So, Mana for Life is the company, and Manico is the wonderful founder, and she has Made for More, an amazing book that comes with she has speaking engagements, inspirational messages. She has a audio.
Oh gosh, I think he's having trouble with his internet connection. But if you're enjoying this and you're watching us, he'll pop right back on. He's had some issues with his internet connection. Again, if you have any questions that we can answer while we're live, definitely paste them into the comments and we'll see if we can get to them later. And here he is. He's back. Okay, we got you.
Okay, so like I was saying, so Mana for Life has this amazing Made for More brand she's been building since at least 2016. And along comes Rachel Hollis, this social media star who decides that she wants to make it big by having even bigger by having a one of her speaking series filmed and recorded and pushed out as Made for More. The problem is my clients got the Made for More rights. Mana for Life owns Made for More for speaking engagements and everything else. The exact same product, just a very different way of providing it. Let me tell you what, Manico is the real deal. And the way she speaks from her heart, the way she encourages her audience is the real deal. Rachel Hollis, I will say that there's a long complaint we filed for the various ways she's used Made for More, even though it's a registered trademark of Manna for Life. And she's used it in ways that bring attention to a company that is upstanding, but sort of tie it up with all the stuff that goes with Rachel Hollis. So unfortunately, we hope she will make it right and that we will figure something out, a solution. But at the time, all we have is someone who's using a trademark that that in many ways, you can already see it in the social media space, is impugning the amazing brand and reputation of Manna Co. With some of the negativity that surrounds Rachel Hollis. So what's interesting about that case is the social media world has really been a buzz about it, picked it up, because these are motivational speakers, motivational products, and what you have is a very interesting case that has a lot of juice for everyone to just pay attention to. And it involves somebody who Rachel Hollis has been criticized for a long time as sort of pushing the line with folks. And it looks like we were the first folks to finally bring a lawsuit about it.
Mm-hmm. Now, in something like that, like let's just say you file a lawsuit, you've done all your due diligence to protect yourself, and the person just doesn't respond at all, or what ends up happening? Is there ever a resolution? I don't know how any of this works.
Absolutely.
Never.
95% of cases in federal court, and that's all generally all meaningful IP cases are in federal court, 95% settle or resolve or have some sort of judgment entered before they ever get to trial. So literally you're only going the full arc of a case 5%. And it does change depending on the judge, depending on the type of case, depending on really how acrimonious folks are. But that's a little comforting for folks. It can be expensive to get through litigation. There are a number of organizations that put out the average price of, for example, copyright cases or patent cases. And it can be staggering for folks, especially small businesses. The good news is Congress has seen fit to, in general, include provisions that allow pretty broad ability for the judge to, at the end of the case, make the defendant that loses pay for the plaintiff's legal fees, or reimburse them for those fees. So there are some protections there, but if you have a lawyer who is not only a fighter but also a person who likes to bridge the gap and try to find solutions, creative, then you have a better chance at fitting within that 95% and finding a way to work it out.
That's good to know. Yeah, I would hope that they would want to do that.
You would, but some of these, especially some of these bigger companies, you just don't know. Some of them like to make examples. I remember there was a lawsuit that it's interesting. I represented Yahoo and I sued Google. So I've kind of been on both sides of it, even with just that. And I recall seeing how aggressively Google litigated. And I think it was really, there was an aspect of wanting to make a point out of the lawsuit that was going on. So you do have to be wary of that possibility that, for everybody, this case might be about just two people that are defending. It might be about some sort of messaging that they're in the broader marketplace.
I understand what you're saying, to bring something more high profile to make a point. So the last one that we had highlighted was, oh my goodness, I just had a.
That's the Lontex versus Nike case, I believe it was.
Case, yes, absolutely.
Absolutely, and that really is the case that has been pending for the longest. Is trial set for it's in January right now, but it's probably going to get pushed. COVID really has taken a number on federal cases, but we've all pretty much got the hang of it, how to litigate remotely now. Everything except for jury trials. I think people are still wary of that, understandably so. But look, that is a case that involves, the First Amendment complaint talks about over $40 million in profits that Nike made by using Lontex's cool compression trademark. Now, what's interesting there is the cool compression trademark is a trademark that Lontex, who everyone knows is sweated out, has used for over a decade. And it used it because it wanted to have it sells to the NFL, the MLB, a whole bunch of teams. It's sold to mostly every professional team or folks in it that you could think of. and it's been doing so for 30 years because people know that it's stretch compression clothing, whether it's a shirt or whether it's tights or whether it's shorts or whether it's capris, will literally help you extend your exercise. It will help you avoid fatigue. It'll help you recover. Has all these benefits because it actually is made out of stuff that works. So my client sweated out, decided to call that cool compression technology back in 2008, around there, 2007, 2008. And in 2015, Nike decided that it would launch a number of products that had the cool compression name. And these products were literally compression products that were competitive, distributed to some of the same teams, the same folks. And even when we talked to them about stopping, it was another 2 years before they ever even bothered mentioning it to their retailers, who, by the way, sell about 70% of Nike's products. So you can imagine the client, after trying to work it out with a company that big and trying to find some solution, eventually decided they won't even stop after 2 years after I told them about it. Yeah. It's time to take matters to court, and that's what they had to do. And we're very excited about that case because the evidence has developed really wonderfully. We have some trainers that have come forward for the NFL and Major League Baseball teams, some former trainers who just retired who have said, hey, I'll raise my hand and I'll let you know that absolutely this is a great product. The technology works. Cool compression is an amazing technology that we use all over the place and have for years, and really validated Sweat It Out's technology so that folks can know it's the real deal. We are not, all of my plaintiffs are not, when I do plaintiff side cases, I do defense side cases. My plaintiffs all have compelling stories. I do not take cases just because I think someone has some sort of potential home run. I take cases of plaintiffs that I believe in, that have real products, that have real passion, and that I think the wrong needs to be righted, and the defendant has done something pretty unexcusable here.
Is it common that you've notified and sent cease and desist letters to people, and they just and it just turns into where you have to file? Is that pretty typical?
Yeah, for each of the 3 lawsuits we just talked about, there was a letter that went out before there was an attempt to reach a resolution. And I think that for whatever reason, maybe because they were smaller companies, because the folks thought that they could just do it. They've been doing it for other things, or they thought it would just kind of slide by. They were unwilling to do so, and so here we are.
So I know we're about 8:30, which is about 30 minutes in, and I said we would try to cut it 30 to 45 minutes. So did you have anything else that you want to talk about tonight, that you think would be helpful for business owners, or just in general, things people may not know, kind of like odd facts about a trademark or copyright?
Yeah, I think there's some odd things you should know for trademarks. If you have a trademark and you get it federally registered, if you don't get it federally registered, you have to prove every single geography or market that and type of good that you claim ownership for. So if you ever had someone, especially if, say, you're in California and they're in Minnesota, use that as an example. There's no presumption that you have rights in Minnesota just because you were first to it in the U.S. But if you promptly file a trademark application, you get it registered as a federal trademark when you start using it, or even you can actually do it, you can file before you start using it. And once you start using it and then you register, as of the date that you applied, or as of the date you said it was your first time you used it in the US, you're presumed to be an owner across the whole country. And you are the owner across the whole country as long as you actually did make sufficient use in one area. So the federal government basically says, we're going to make sure you have the exclusive right across the country, as long as you were first to do it and first to register it, as long as you come to us and get a registration. That is so powerful because you may find yourself, like I did in another case, my client was the last comer in the US, but they were the first to get a federal registration. And guess what? We worked it out so that my client gets most of the US to use the trademark, and the original user, who was a smaller company over across this other side of the country, literally is limited to a much smaller geography. So that's the trademark land. So I really encourage you guys, and if you have a registration, federal registration, it cuts off a whole bunch of arguments that that a person can make when they steal your trademark.
Mm.
And it makes sure that people know. Because look, for honest people, they go to uspto.gov, they search for a trademark, and they see if someone's using it before they take it. So
Mhm.
if you want to cut out honest people who literally are just bummed that they picked the wrong trademark and not have to have a fight with them about it, get it on the register, and then you'll make sure that folks have the best chance if they want to find you and to know that you're out there. So that's trademark land. Um, I think I could tell you crazy war stories up the wazoo. I remember the Winnie the Pooh case. I was on that case. That was one of my first cases. And Disney tried to cut the rights out from the family that owned the Winnie the Pooh rights that had
Oh.
sold them to Disney. Um, and the judge saw through it and said, "No, you can't cut someone out of the middle of it and take all the money for yourself." But that was right at the beginning of my career, and that's one of the reasons I knew, gosh, I'd really love to do intellectual property the whole time. So I think I'm in stream, but you're not. So perhaps I should answer any questions. If anyone has any questions, feel free to put it in the box. Looks like we got some good comments. I'm glad you guys are enjoying this. And when she comes back on, we can answer any questions she has. But I was going to say, for patents, that's probably it's a long, long process to get a patent. So don't wait to start that. And you got to do it right away. Otherwise, you're not going to own it. Once you come out with a product and you haven't filed for patents, most likely you don't own that patent. And it is literally any technology you've invented has gone into the public domain free for other folks to use. So you have to file for a patent, and you have to try to do it really before you launch the product that uses the technology, to make sure that you don't lose the value of the monopoly that you get from a patent. I'm going to hang tight, see if Kevin comes back on.
Yep. I am
Oh.
here.
Oh, you're there. I just did a little monologue for you while I was.
I know. I don't think you can, which is okay. My daughter just got home, so I kind of snuck off, but that's perfect.
Oh, that's great. So I just explaining how patents you really don't own. If you come out with a product and you had the most amazing, you figured out how to solve the world's energy problem, and you sold the product with it first, tough luck. Like the rest of the world just gets the benefit of that, and you don't get any money for it. So it's really important.
Larry Wagner says, "What is your company name?" Troutman Pepper.
Troutman Pepper. Yes, we merged in. So Troutman Pepper is a AmLaw. I think it's going to be effectively one of 50 largest firms in the United States. We just merged July 1st and combined to make this wonderful company. And we have an amazing intellectual property group. Got amazing everything, but it's a full service firm that helps folks from all different walks of life and all different businesses.
Okay. Any other questions for Ben while he's here? I can't think of anything else that I.
Well, I'll just give a final word of, I found myself in this career really. I come from a family of quadruplets. We were all musicians, and my dad owns a small music school that was just really well regarded in the community. My father-in-law, he owned a small business as well. So, I represented big companies and small companies, but the cases I just told you about are really small folks who have worked really hard, whether it's 30 years or whether it's just really hard over a couple years to build something. And when folks build something and someone else takes it, that really gets me passionate. I've seen how hard it is to build something from scratch, to build a place for yourself. I've seen that, most of America, regardless of, there's our bigger companies that we work with, but I enjoy the smaller companies because I certainly come from a family of small business, and sometimes we need to find creative ways to make sure those folks get the representation of a firm that's top notch like ours, and we find solutions But I really enjoy it because it's allowed me to be on both sides of the equation, but to be on sides and do things that really make me feel like I'm making an impact and not just, like I'm representing their client that at the end of the day, it's a business deal. So I feel like we're going really far past business deals and making an impact on people's lives. So that's a great thing to feel, especially when you're working, day in and day out for corporate America, to feel like you're really a part of something individual and personal and meaningful to actual people is something that I look forward to every day.
Oh, that's awesome. A lot of people can't say that about their job. And you're right about small businesses. If you've never started a small business, it is not for the faint of heart, especially if you're bootstrapping the entire thing. So hats off to people like you who protect all of us out here trying to grow something. It is definitely such an interesting field, and I learned a lot actually tonight, because there's a lot of myths out there. And even if you search some of the names of these cases that he talked about tonight, you'll see a lot of armchair lawyers, I guess you could call them, saying that they think is true about trademark and copyright. And so there's plenty of misinformation out there. So thank you so much, Ben, for coming on and actually explaining the truth and the right answers behind some of these questions that people have all the time, because it's important that you know what you need to protect and how to keep yourself protected, especially if a larger company takes an interest in something that you've created. You definitely need somebody like Ben on your side to help you through things like that.
Absolutely. Well, I'm glad to have been here. I'm glad that each of my clients trust me with the cases, and I love them and I trust them. And whether it's Manico being a motivational, inspirational person to so many people, and or it's Ephraim Nathan, who's the owner of Sweat It Out, who just pours his heart out to these teams, these pro teams, and the players. I mean, he's just telling me about how he's on the phone, rushing, staying late at night to make sure to literally get products sewn so it can get off to players before they get to the field. I mean, and Justin, with just the amazing advertising that folks like LifeProof got off of him, and so young to be so talented. So I'm glad they all trusted me, and I'll continue to earn every client's trust. And I'm happy to answer questions for folks. They can all look me up, and as long as it's generic legal information and not advice, I'm happy to give it.
And if you have any other after this, if you're seeing this after it's live and on a replay, whether it's on here, on YouTube or LinkedIn or the other channels that will be sharing it, feel free to comment below. And if it's something that I know that we can pass on to Ben, I'll make sure he gets it. And and then I'll let him reach back out to me with any information that he has. So thank you all for joining us tonight. It is 8:41 East Coast time. So I hope you all have a great evening, and this has just been really helpful. So thanks so much for watching. And again, reach out to us. We're here to help.
Thanks.
Mhm.